Greetings, fellow freethinkers. The event you're about to watch was hosted by the Centre for Inquiry Ontario, an educational and outreach organization dedicated to promoting and defending science, reason, and free inquiry in every area of human endeavor. My name is Justin Trottier, and as Executive Director of CFI Ontario, I would like to take a minute to tell you about us. Our centre, located in the heart of downtown Toronto, is the first Canadian branch of CFI and is our nation's first dedicated meeting and event space for humanists and freethinkers. Our mandate encompasses a robust public education presentation series throughout Ontario, campus outreach as we support a growing network of student freethought groups, community outreach and social services to provide humanistic alternatives to religiously monopolized services and activities, and a lending library and media center that, among other things, broadcasts videos like this across the planet. To learn more, please visit us at cfiontario.org. To get on our email list or to learn how you can support our movement or get a freethought group started at your campus, simply contact us today at info@cfiontario.org. Thank you for your time, and I hope you enjoy the video. Okay, just a few quick words. Just wanted to tell you a bit about our upcoming events before I introduce our speaker for the evening. Those of you who haven't, please on your way out grab a copy of our newsletter so you know what's coming up. We mail these out once every 2 months. This is the one that will carry us into the end of June. The one for July and August should be mailed over very soon. The next lecture in our ongoing Voices of Reason series will be on June 6th. We have John Novak, who is a professor at Brock University, also a frequent contributor to Free Inquiry magazine, speaking on the topic of appreciating the human perspective, an invitation to educational living. So I urge you to join us for that. Following that, we'll have Greta Vosper in June 20th, I believe. Greta recently authored a book called With or Without God. Quite interesting. She's with the Progressive Christianity Association. A few other things. In the political side of things, we are very much involved in submissions to the Queen's Park Lord's Prayer Committee. The deadline has passed as far as written submissions go, but if you would still like to participate in that ongoing campaign, then please come talk to me. There's still emails and phone calls that can be done. We've also been invited, the CFI that is, to actually meet with the committee and present in person our points of view on this issue, so we're preparing for that as we speak. Other than that, we have drinks for sale at the back, so we'll do a short intermission before Q&A, and you can take advantage of that. And let me get to today's event. So we have with us a very special speaker from CFI's Los Angeles office, CFI West, Edward Tabash. Eddie Tabash is a Los Angeles attorney and chair of the CFI's First Amendment Task Force, on whose behalf he filed one of the briefs on the winning side of the California Supreme Court split decision to allow same-sex marriage on May 15th. Eddie argued to the California High Court that the ban on same-sex marriage is grounded in religious dogma and hence violates the separation of church and state. A former two-time runner-up for a seat in the California legislature, he pledges to be active in attempting to defeat a possible ballot by the religious right to overturn the decision in November. In the meantime, the Center for Inquiry and its allies celebrates the current victory for human rights and fundamental equality. Eddie Tabash is a specialist in the application of the United States Constitution to controversies swirling around religion and secularism. He's an appointee of Congressman Brad Sherman to the State Central Committee of the California Democrat Party, and also chairs the National Legal Association for Americans United for the Separation of Church and State. He is here making his first election year presentation outside of the US, informing Canadians about the grave threat to the fabric of the US secular government that is at issue in the current presidential election. Please help me welcome Edward Tabash.
It's an exceptional privilege for me to be here in this wonderful country of Canada, because were it not for Canada, I would not exist. Right before the Nazi invasion of Lithuania, my father was an Orthodox rabbi in that country, and his entire family was killed in the Holocaust. The only reason my father survived was he got a visa to come to this country and spent the war years here. So it is because of Canada that my father didn't die at the age of 27, but died at the age of 89. And I cannot come here without acknowledging that, in a sense, it was this nation that paved the way for me to be here to speak to you about the threat of the religious right. As Canadians look south, you will see a nation embroiled in a pivotal presidential election. But one thing you will not see discussed in the news media is that whether or not America remains a secular nation or becomes a theocracy hinges on who replaces one 88-year-old justice on the United States Supreme Court. People outside the United States, and even in the United States, have difficulty comprehending how a shift of one vote on the United States Supreme Court could result in a reinterpretation of the Constitution. Well, that's absolutely true, because the Constitution of the United States means no more than a majority of a minimum of 5 justices on the U.S. Supreme Court say it means at any given juncture in history. And so on the United States Supreme Court now, there is a 5-4 split. 5 justices still correctly hold that the First Amendment requires government to be neutral between believer and non-believer. 4 justices chillingly take the view that government at all branches in the United States may favor the religious collectively over the non-believer as long as they don't single out any particular religion for favoritism. And so it is this technical point which determines whether American government remains neutral and treats all of us equally, or whether the government can undergo a sea change and begin to treat believers collectively as first-class citizens and the non-believer shunted off into second-class citizenship. But before I get into the list of horribles of what is happening with the religious right, I have a few caveats. First, because I represent a non-profit entity in the United States, the Center for Inquiry, I cannot explicitly endorse or oppose any specific candidate for the presidency, even though I am speaking outside the United States. But I can inform you as to who the players are and what the position is. Secondly, before we begin the list of horribles, I'm going to take you through some history, much of which is in your handout, to demonstrate that, amazingly, the founders of the American constitutional scheme in the 1780s really did intend government neutrality in matters of religion. First of all, before we get to the First Amendment and the other 9 amendments that constitute the Bill of Rights, when the 55 authors of the original Constitution in 1787 gathered, they refused to pray for guidance. That is a sign of a secular intent. Also, the original United States Constitution, even prior to the addition of the Bill of Rights containing the First Amendment, had only one reference to religion, and that was a negative one. Article 6, Clause 3 prohibited any religious test for public office. And even a future Supreme Court justice said during the debates on that provision that it would be fine if pagans and people with no religion were elected to office. Now, the key players in the creation of a governmental scheme that separates God and government were actually the future 3rd President of the United States, Thomas Jefferson, and the future 4th President of the United States, James Madison. And these 2 people, more than anyone else, were responsible for guiding the American fledgling government to a position of a point of strict government neutrality. Now, Madison, influenced by Jefferson, was the actual initial author of the First Amendment. And to demonstrate his intent to keep government and God separate, and to demonstrate that today's religious right is wrong when they claim that our government was founded in order to allow favoritism for religion collectively, in 1785, 4 years before submitting the initial draft of the First Amendment, Madison opposed taxation in his native Virginia, which would have benefited all clergy. That's a sign that he wouldn't even approve of the collective support of all religion, even though they were all Christian denominations. But very tellingly, in 1786, Madison secured, through the Virginia legislature, the bill authored by Thomas Jefferson and himself, the Virginia Statute for Religious Freedom, which shielded minority viewpoints on religion against the tyranny of the majority. And non-believers were also protected. And proof of this came later in 1821, where Jefferson wrote in his autobiography how happy he was that he and Madison defeated efforts to dilute the statute to protect only Christians. Jefferson was delighted that, in his words, he and Madison secured the passage of a bill that protected everyone, including the infidel of every denomination. The infidel of every denomination shows an intent to protect the non-believer as well as the believer. Now, since the two of them were the major influences on each other, the words of one can be attributed to the other in terms of their feelings on the separation of God and government. In 1787, Jefferson published his Notes on Virginia, in which he wrote, "It does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg." Imagine any American or possibly even Canadian politician saying that today. And if we go back in time precisely 200 years, we would find Thomas Jefferson sitting in the White House. Now, sometimes I believe that could be scientific evidence that evolution goes in reverse. But nevertheless, that is the reality. Now, in 1788, Madison, writing in Federalist Paper number 42, urging ratification of the Constitution, defended the prohibition against any religious test for office, and Madison said that public office should be open to merit of every description without regard to any particular profession of faith. But a most important communication occurred in October of 1788, where Madison, just a few months before submitting the initial draft of the First Amendment, in a letter to Jefferson, expressed concern that people would deny infidels the right to hold office. In this very same letter, Madison also expressed his fear that the general public would substantially narrow the rights of conscience if given the chance. This definitely shows that he intended to protect the non-believer equally, and it shows that he intended government neutrality, not collective government favoritism for religion at the expense of the non-believer. And in June of 1789, Madison, as a member of the very first United States Congress, proposed an amendment to the Constitution that would ultimately become the First Amendment. It prevented government from abridging the civil rights of anyone because of religious belief or worship. Madison's first draft also prevented government from establishing any national religion, and it prevented infringement upon the equal rights of conscience. The debates from both houses of Congress are a little sparse during that summer of 1789. But what we do have shows an intent on the part of the members of Congress whose words were recorded and whose actions were documented to preserve the rights of conscience for everyone. And it seems that the preoccupation with the founders was to preserve individual freedom of thought and to avoid all government favoritism, whether one is a believer or a non-believer. And this can be summed up in the words of Representative Daniel Carroll, who said, "The rights of conscience are in their nature of peculiar delicacy and will little bear the gentlest touch of governmental hand." That shows the pervasive nature of the desire to protect all viewpoints on matters of religion. Now, if indeed the religious right and their allies on the Supreme Court are correct in saying that government is permitted to support religion collectively over non-belief and is not required to assert total neutrality between believer and non-believer, then we have the inexplicable rejection of the United States Senate on September 3rd, 1789, of two proposed wordings of the First Amendment that would have done just that. One would have said, no law establishing one religious sect or society in preference to any other. The other would have said, no law establishing any particular denomination or religion in preference to any other. So if indeed the Congress intended to prevent government from only favoring one religion over another, but freeing government to favor all religions over non-belief, either of these two proposed wordings would have been adopted, but they were rejected and never brought back by either the House or the Senate. So that is conclusive proof that the drafters of the First Amendment considered what the religious right says is the proper interpretation and definitively rejected it. And when the First Amendment went to the House and Senate Conference Committee in September of 1789, the final language was the most sweeping. No law respecting an establishment of religion. Not just no law establishing a national religion, or no law favoring one religion over the other, no law showing respect to an establishment of religion. And that is the basis for our claim that the intent was government neutrality. And then Jefferson in 1802 wrote that the First Amendment built a wall of separation between church and state. And to show you how powerful were the sentiments of Madison and Jefferson against mixing of God and government, their policies and statements were much stronger in the direction of church-state separation than we see today, even among the most pro-church-state separationists in America. Madison was so concerned about the accumulation of power by religious institutions, he had misgivings about a religious organization's even holding property. Jefferson, as president, refused to issue Thanksgiving proclamations because he felt such proclamations were religious exercises. And Madison even opposed tax exemptions for property already owned by religious institutions. If those most present and most responsible for the creation of the First Amendment held this view, then certainly the First Amendment, by its historical founding, is a charter for neutral government, not government that can favor religion collectively. It's true that in the beginning years, the First Amendment applied only to the national federal government. But in 1868, the Equal Protection Law, the 14th Amendment to the United States Constitution, was ratified. And that incorporated to all the states the protections of the Bill of Rights. So properly now, it can't be the case that Alabama or Georgia or Mississippi can vary the degree of liberty and that you can have more free expression in New York State than you can in Louisiana, because the standard must be uniform, because the First Amendment and the entire Constitution is binding on all the states. Now, an individual state can give more freedom than the national Constitution, but it cannot give less. The national Constitution provides a floor, not a ceiling. So no individual state can give someone less freedom, but they can give more. And since 1947, there has always been a majority on the Supreme Court to say, no branch of government may favor one religion over another, or may favor religion collectively over non-belief, and no one may be punished in any way for either professing or rejecting any tenet of religious faith. But now, for the first time, we stand on the threshold of losing that blanket protection for all rights of conscience, and the President of the United States, who replaces 88-year-old Justice Stevens, will determine if government neutrality, which means separation of church and state, continues in the United States, or whether those who believe that government can support religion collectively will gain their fifth vote and overturn more than 61 years of precedent. And that is what is at stake in this election. Among the four justices who would wipe out the doctrine of neutral government is Justice Antonin Scalia, who says the First Amendment does not protect the devout atheist. But the most extreme is Clarence Thomas, appointed by President Bush Sr. in 1991, who takes the view that the Establishment Clause doesn't even apply to the states, but that therefore each state should be free to have their own official religion and own official church. Justice Thomas is giving a recipe for religious civil war in the United States. Now, before I get into the list of horribles as to what the religious right is doing, let me just state, by way of factual presentation, that both Hillary Clinton and Barack Obama have promised church-state separationists on the Supreme Court, and for the past 6 weeks, Senator John McCain has said that if elected, he will put on the Supreme Court justices that will effectively repeal church-state separation and reproductive freedoms, and that the types of justices he would appoint would reflect the will of the people. That is code for saying that the intent of the Bill of Rights would be nullified, because the First Amendment is meant to be a counter-majoritarian document. It doesn't matter how many people despise a form of expression, it cannot be banned. It doesn't matter how many people support a particular religion, it cannot be enacted. As the Supreme Court said in 1943, the protections of the First Amendment depend on the outcome of no vote and the outcome of no election, and no government official, high or low, can say what is orthodox in matters of politics, patriotism, and religion. But all this would be nullified if the Supreme Court listened to the will of the people. Now, before I launch into the list of horribles, let me say that the attacks I'm about to provide on the Republican